All right, today we're going to dive into a really fascinating case from the Delhi High Court back in 2010. Now, on the surface, it might look like it's just about some dry legal rules, but trust me, it's actually a story about how our courts fight back to protect themselves and all of us from being played from the inside. Let's break it down. I mean, think about that for a second. The very rules that are designed to make sure everyone gets a fair shot, what happens when they get twisted and used to stop the game from even being played? Well, this case is a perfect example of that exact problem, and more importantly, how one judge decided he'd had enough. So, where did this all start? It wasn't some huge, complex corporate lawsuit. Nope. It began with something incredibly human, a woman simply asking for financial support.
At the heart of it all is a maintenance petition. A woman, Miss Kamlesh, filed it. This is a pretty standard legal step, designed to get support to people who need it and quickly. The stakes couldn't have been more real or more personal. But instead of getting that support, she ran into a wall built out of paperwork. Her case just got bogged down by a whole series of motions and applications that really only seem to have one goal: delay, obstruct, and just hope she gives up. So what does a delay like this actually look like on paper? Well, the court record tells a story of one frustrating postponement after another. Let's actually walk through the timeline.
Okay, just look at this pattern. It's kind of wild. February 2007, the lawyer's sick. Bam, adjournment granted. April, a death in the family. Okay, adjournment. July, a fever. September, another fever. I mean, come on. Each time the court grants a delay. It gets to the point where the court even closes the cross-examination, but then allows it to be reopened, only to be hit with another request for more time. You can literally feel the judge's patience wearing thinner and thinner just by reading the case file.
So when you're a judge and you're seeing this clear pattern of obstruction, what can you actually do about it? Well, it turns out the law has a pretty powerful set of tools to stop the system from being hijacked like this. The judge in this case, Justice Dhingra, he saw exactly what was happening. He called it what it was, a classic abuse of process. And this is a really key idea. It basically means you're using the rules of the game not to play fair, but to make sure the game can't be played at all. So how did he fight back? He used three key powers. First, there's Section 151, which basically gives courts inherent powers to do whatever it takes to see justice done. Think of it as a legal failsafe. Second, Order VI Rule 16, which lets a judge literally strike out nonsense arguments from the record. And third, he relied on a basic principle. You can't just keep filing the same application over and over and over again. Look, these aren't just some dusty technical rules. You can think of them as the legal system's immune system. They give a judge the power to be a guardian, right? To protect the court's integrity and make sure the whole process doesn't just grind to a halt because someone's playing games. And it's really important to get what this judgment was and what it wasn't. It was a powerful ruling on procedure. It was not a disciplinary action against the lawyer. The judge imposed costs to stop this from happening again, but that's totally different from a criminal fine or a contempt of court charge. The whole point was to fix the process, not to punish the person. So after figuring out the problem and picking the right tools, Justice Dhingra delivered a verdict that was just incredibly direct. He left zero doubt about what he thought of these tactics. His words from the ruling are so sharp. He wrote, and I'm quoting here, "It is considered as if courts exist for providing business to the advocates. This attitude towards the litigation and courts must be brought to an end." Wow. That is a powerful smackdown of the idea that a courtroom is just a place for lawyers to make money instead of a place for justice. And he backed those words up with action. He slammed the petitioner with a cost of 25,000 rupees. Now, you gotta remember, back in 2010, that was a pretty significant amount of money. This wasn't just a slap on the wrist, it was a real financial deterrent meant to make anyone think twice before trying this again. And he didn't just stop with the client. The judge had some very pointed words for the lawyer, too. He basically reminded him that a lawyer's first duty is to the court and to justice itself, not to just blindly follow a client's instructions to gum up the works. So, okay, why are we still talking about this one specific procedural case from over a decade ago? Because the ideas it stands for, they're absolutely timeless and probably more important today than ever before.
This case really hammers home four huge ideas. Number one, procedure is supposed to serve justice, not be used as a weapon to kill it. Two, if you're going to use financial penalties to stop abuse, they have to have real teeth. Three, a lawyer's number one loyalty is to the court's integrity. And four, lawsuits have to end. You can't just keep fighting the same fight forever. There has to be a resolution.
And when you think about how backed up and delayed our court systems are today, you get why this is so critical. The principles Justice Dhingra laid out here are like a blueprint for how to get things done efficiently, with accountability, and ultimately deliver justice on time.
And that kind of leaves us with one last big question to think about. In this case, the judge issued a stern warning, but is that really enough? Should lawyers who knowingly and repeatedly use these tactics to delay justice, should they face even tougher consequences? It's definitely something worth chewing on.